My lord, may I be permitted to mention a matter, my lord, which was disposed of, my lord, by the order dated 8th August 2012, my lord, where a bank guarantee was kept pending, my lord, till the disposal of the arbitration proceeding, my lord. My lord, the arbitration proceeding has been disposed of in the year 2019, my lord. My lord, now an order has to be passed to the extent, my lord, by your lordship, for release of the bank guarantee, my lord. I had approached before the registrar, my lord. The registrar has given a communication that unless an order to that extent is passed, my lord.
File an application. File an application.
I'm grateful, my lord.
Yes.
May I have, my lord, may I have your kind leave to file an appeal without a certified copy of order dated 12th April. We had applied in the 25th of this month. You're yet to receive the certified copy.
My lord, if I may have my lord's kind leave, my lord, to mention two appeals, my lord, under section 37, my lord. My lord, this arises, my lord, out of an order passed by the learned city civil court.
There are many CAVs. There are many CAVs which are there.
The problem is, my lord, this is an appeal, my lord, arising out of a section 9 proceeding, my lord, by the learned city civil court. Your lordship has a
then
regular
release,
determination.
Release.
Grateful, my lord.
But city civil court, the arbitration appeals.
Arbitration appeal, my
Okay.
lord. Your lordship has the regular
Release
determination.
kora to be mentioned at the other.
Grateful, my lord.
Yes, call the next.
New application item number 1.
My lord, now I'm appearing on behalf of the appellant, my lord. The appeal is arising out of an impugned order dated 23rd of March passed by the arbitration court. My lord, on the last occasion, the matter was taken up of 20th April. My lord, this relates to a machine which my client had procured and had surrendered due to default in payments. Now, my learned friend's client, they are in physical possession of the same. They have also received a bid.
Have you read it?
Yes, my lord. We have taken instruction. We have written instruction as well. My lord had
Deposit.
directed
Deposit
that
the
we should-
money.
My lord, just one indulgence, if I may just hand up. If it can be kept next Thursday, we shall come with a demand draft, the same amount, 20,50,000.
Bring the money and then we'll
My lord,
adjourn for a week.
grateful.
Adjourn for a week. Next Thursday.
Item number 2, 3, and 4.
The issue is condonation of delay. Now,
How much?
delay, initially we had computed delay at 193 days, but then we found that in view of the suo motu order of the Supreme Court, the delay is 37 days. 153 days. It was now recomputed at 37 days. Your lordship
Have you served the copy on the other side?
Your lordship had thereafter allowed us to file a supplementary affidavit also, to which they have filed a reply.
What is this new application? If this matter was heard before,
There was a similar matter that your lordships had heard before, and
Huh?
that your lordships were pleased to reject.
New 2, 3, and 4 new application. Oh. Yes.
Well, I must point out one thing. Well, there was a similar matter. Well, where your lordships had passed an order on 1st December 2022. Well, refusing to condone the delay.
Unusual.
Yes. Now, the difference is this. So far as we are concerned, we are the Citibank, Kolkata branch. Now, the guarantee had been given by the bank, Citibank at Bangladesh. The question was that whether Citibank Bangladesh and Citibank Kolkata are the same entities. If your lordship sees the impugned order, the contention that was raised was that they are not the same entities, and in fact, the judgments of our High Court division bench, which says that banks having their branches at two different jurisdictions, they are not the same entities, and in fact, these are two different countries. Citibank of Bangladesh and Citibank at Kolkata branch. Now, in these circumstances, the confusion was as to whether, my lord, we should pursue the matter at all, or, my lord, should Bangladesh should be who should pursue the matter. But, my lord, then, my lord, we realized that the judgment had been passed against us. So, my lord, we have to, my lord, necessarily prefer the appeal. My lord, this is a confusion that, my lord, prevailed for quite some time. We contested the matter before the single judge, but thereafter, my lord, the Eastern Bank, my lord, had filed an appeal.
Separate matter altogether. They were not a party.
My lord, we were wondering, my lord, whether we need to file an appeal at all, whether the order will bind us. But, my lord, then apparently, my lord, contempt proceedings were started. So, my lord, we ultimately had to take a call.
How the contempt proceeding against you when you were not there?
Oh, I'm sorry, my lord, that is, my lord, that is separate. I'm sorry, my lord, I'm confusing you with some other matter. Well, that is a separate matter. Well, kindly have a look at, my lord, just one or two documents.
See, if there is no directions passed upon you, then you can't be termed as
No,
an.
my lord, kindly
executive.
see, my lord, the impugned order once. I shall show you, lordship,
Yes,
why, my lord.
which portion that according to you affects your right?
Yes, my lord. Well, if your lordship will kindly, my lord, take up, my lord, the memo of appeal one.
Yes, I have.
My lord, kindly see, my lord, page 9 of the order.
On page 9.
Well, at paragraph 16, it would be evident from the transaction that the petitioner, respondent number 1, and Citibank NA Kolkata, respondent number 2,
Yes.
treated Citibank NA Bangladesh at Dhaka as an overseas office of Citibank NA Kolkata. Citibank NA carries on business from different offices in India, including one at Kolkata. Since the petitioner was required to submit a performance guarantee security in the form of bank guarantee for a sum of such and such, the petitioner applied before the respondent number 2 at its office at Kolkata for a bank guarantee to comply with the stipulation. The application for bank guarantee was made by the petitioner on 2nd November at Citibank NA in Kolkata, whereupon, this is important, Citibank from its office at Kolkata issued a standby letter of credit in favor of Citibank at Dhaka. On the basis of such standby letter of credit, Citibank Dhaka issued a performance security in the form of bank guarantee as the overseas office of Citibank NA Kolkata. Now, my lord, all that I had given was a standby letter of credit. My lord, a standby letter of credit is, my lord, something which, my lord, is really guaranteeing the letter of credit that is to be issued by the other bank. Now, my lord, today I am not, my lord, the bank which issued the guarantee. The order of restraint was on the guarantee. My lord, that order of restraint could not operate against me, and I could not, my lord, myself prevent, my lord, the guarantee amount from being paid by the, my lord, Bank of Bangladesh. My lord, these are the facts, my lord, which came to prevail. Now, my lord, 17, the above facts would therefore indicate that Citibank NA from its overseas office at Dhaka issued the performance security.
Last sentence is the main, that no fact has therefore been placed or proved to show that Citibank New York should be seen as two separate distinct entities in Kolkata and the Dhaka branches. So the company is one and the same.
No.
It has
My
a.
lord, that is, my lord, exactly what I'm saying. The law, my lord, your lordships have laid down very categorically.
Yeah.
Your lordships have, my lord, held that, my lord, two, my lord, banks, my lord, same bank, having, my lord, two different branches, my lord, there are two different, my lord, banks for the purposes of transactions. My lord, that is, my lord, settled law. And, my lord, not only that, my lord, the registration, if your lordship sees, my lord, the affidavits, my lord, which I should show you, lordship, my lord, these are, my lord, registered in two different entities. My lord, the question therefore would be, my lord, am I, my lord, then to be made liable for, my lord, the violation of the order by the Bangladesh Bank? My lord, this honorable court felt that, my lord, the performance guarantee should not be encashed. My lord, it was, however, encashed by Bangladesh, not by me. But, my lord, here I am, my lord, ultimately facing the music, because, my lord, the treatment is that as if I am the same with Bangladesh. But that is why, my lord, I need to pursue the appeal. Ultimately, your lordship may, my lord.
Where is the supplementary affidavit?
Well, my petition, my lord, was very bare. I conceded before your lordship, and your lordship granted me leave to file a supplementary affidavit. Well, that, my lord, we filed in February. Yes. Well, this was 14th February 2023. My lord, I filed a supplementary affidavit. And my lord, if your lordship sees page 3, paragraph 3 of the affidavit.
That is also the problem in instrument.
Well, if- Well, if your lordship will kindly have a look at the supplementary affidavit. Yes.
I have already read.
Well, the delay is well, really 37 days. Well,
What is their stand?
well, their stand is that my conduct is bad, I am visited by malafides, so on and
Yes,
so
what
forth.
do you
So
say?
delay should
What
not
do you
be
say
taken.
about this?
Factually, this is a worse case than the previous one which Lordship had dealt. Here, my lord, Citibank had contested it throughout. Lordship would recall the language of the learned judges, their shadow boxing. That is the language used. And then, my lord, as an afterthought, because of certain developments subsequently.
No, that is on the merit. That
Correct.
is on the merit of
Yes,
the appeal.
only on the question of delay, Lordship will find, my lord, the reasoning, what has come even in the supplementary affidavit.
What
that-
they say is that after this order was passed on 23rd, the application for certified copy was made on 29. And then it was made available on 3rd of January. And thereafter they send it. There was a lot
But-
of the conferences that was held. And during the conferences, it appears that an appeal was drafted. Then the learned advocate who was instructed, he was indisposed on a personal reason. And thereafter, the nod was taken from a legal departments. These are all in a corporate world, in a
Well,
government
Lordship will-
department. There are
well,
something which really
But
happens.
this would have made some sense had it been an ordinary commercial, my lord. What is then the point of 60 days? Number one. Number two, my lord, all this is happening, COVID and pendency of COVID is no consequence at all. Because, my lord, the orders and the contest that took place was all in virtual
No,
format.
that is all is there. What they say is that since because of the Omicron having struck, there was a limited functioning of the bank with the limited staffs.
My lord, the order under appeal was passed in the peak of COVID.
Oh, I understand. So far as the councils and the courts proceedings are concerned, they are not blaming that. Rather, the conduct shows that immediately within 6 days, the application for certified copy was applied. There is no fault. The fault really comes from the end of the appellant. And the appellant says that we were having a limited functioning. It is not the court has a limited functionings. But there are various steps which are required by them because the legal department has to be involved. The decision has to be taken. What they say, we are not accepting it, subject to what you will say. Their contention is that these are the formalities which are there. And because of this limited functionings, this took time. And ultimately it was decided, it was sent, drafting was done. Then the senior counsel, like both of you, so busy, do not
No,
give
no, my lord,
the time,
it is,
do
my lord,
not give the
it
time
is-
so
it is
frequently. So
ordinarily,
frequently that if you have come today, I will keep it tomorrow. That
putting
does not
the
happen.
blame on senior counsels, my lord, that is
Yes.
all right. But
So-
this case, my lord, it is not, my lord, nothing.
Merit,
I am not troubling your lordship now.
that can be thrown out, subject to if you
Merit, I am not
contest.
troubling your lordship.
But section
my lord,
5, and it is of 37 days.
my lord, no, my lord, that is, my lord, kindly see the original stay application first.
That's it. Originally, we had said 153 days.
I
That was
understand.
what the department had said.
Anyhow, 153 days was there. There is something which I also have some kind of a confusion in this regard.
My lords.
I tell you very frankly. Because the confusion which has arisen in my mind is that when this suo motu proceeding was initiated by the Supreme Court, wherein they suspended the applicability of the Limitation Act. This was with an intent that wherever the limitation expires during those COVID period, then the parties are unable to take decision. That's why there should be a moratorium period, may I say, a suspended period for limitations. But if the order is passed during this COVID period, whether the advantage of those order can be taken into account is the further, because it remains suspended But one has to understand, these are, I'm not going,
I will,
I'm
my lord,
not going,
I will personally, my lord, tell your lordships that, my lord, we have all taken advantage of the suo motu
I tell
orders
you,
without being
that
entitled to do so.
absolutely, this is what I really found anyhow, but we have been very, liberal in this regard and not interpreting so strictly in that sense. Anyhow, the things are, if those periods are counted, they according to them, it's the 37 or
37 days.
37 days. So if that being the position, and forget about the period of limitations, it is the sufficiency of the cause which really weighed the court. These are the facts which comes, at least so far as a condonation part is concerned. We are not saying anything on a merit. I tell you.
No,
very
no, no.
frankly.
That is all right. Lordship, my lord, only
On the
two
merit,
things I
they may
show
not, they
only
may
two
not
things
succeed.
I'll show
They
your
may not
lordship.
succeed. Shadow
things-
boxing or I
No,
do
no,
not
my lord,
know. It's a,
I'll just show your lordship two things. Kindly takes the original stay petition. Kindly see the first instance when they come, my lord, it is affirmed sometime in July 2022. Now, my lord, the COVID circulars, what is,
we are concerned with the filing of an appeal. We are not concerned when the stay application came to be filed. There is
Yes,
no
well, it was-
limitation for
it
filing
is
the stay application.
in July
I believe
2022.
it was filed on 19th of July 2022.
Correct. Now, my
Not
lord,
written-
kindly see page 14, volume 1, stay petition, page 14.
What do you want to say?
Well, kindly keep para 56 of the main stay petition and compare it with the
What para 56 says?
With regard to the delay in presenting this application, it is stated that the petitioner herein has been examining internally and consulting its counsels
Yes.
to understand the impact and larger ramification of the impugned order,
Correct.
as the nature of the order is such that it not only affects the petitioner in relation to the transaction in dispute, but also overall the guarantees and standby letter of credit of business of bank. Petitioner was also delayed because of the owing to intervening COVID. There has been a delay of 153 days. This is the only paragraph which is there.
Correct. So
Now, when the time
we permitted them to file a supplementary
Correct.
affidavit indicating. Now they have come up with the entire event which has happened, and that starts from paragraph 5 and sub paragraphs therein.
Yes. Now, my lord, kindly comes to my lord, let us take it, my lord. Will lordship exercise the discretion? Let us
Yes.
take the facts and let us take the facts to be true. I am proceeding on the facts to be true. Kindly comes to my lord, page 3.
Correct.
From subparagraph
Roman 1 is very clear. Please bear in mind.
Kindly come to Roman
I
3.
will. Step by steps. Because in a section 5, the sequel is very important.
Correct.
So first is 23rd November order was passed.
Yes.
29th November, the certified copy was applied. No
That is,
problem.
the
Within the
advocate has
limitation.
been very diligent.
3rd January, the certified copy was handed over to them.
Yes.
No problem. Now thereafter, what is their role? Up to this, they do not have any hand in this.
And my lord, para
Now-
2 is Omicron variant is the milder variant. When this entire litigation was being conducted, it was, my lord, through virtual mode at the peak of
No,
COVID.
no, that is a judicial
And
proceeding.
thereafter,
Kindly-
physically
kindly,
also,
Mr.
everybody was present.
Mr.
Now, my lord,
Chaudhary,
kindly see
Mr.
subpara
Chaudhary,
3.
this is a court's proceeding. There is no difficulty. Look at the explanation. So far as their part is concerned, they
But-
say
But
Omicron.
is this believable? No particulars, no, not a single name mentioned. Kindly see subpara 3.
Omicron variant rampant, I do not know, rampage through the entire country from January 22 till approximately March 2022. During this time, this is what is there. The appellant had a limited business hours and limited staff. It may be on a rotational basis. This is
But
what they
the-
say.
My lord, is it the case that the person who has affirmed this affidavit, my lord, he was not coming to court, not coming to office, or he was
That is what is not there. The appellant could not take any constructive steps. There may be some steps taken, but a constructive steps and not decision during this period means up to March 2022.
yes,
Then in April 2022, the legal department, which is situated at Bombay, after examining the impugned order in principle, decided to prefer the
but
instrument.
then my lord, lordship will see if
So-
this para 3 stands, then my lord, in every case, my lord, this will be, and my lord, November 21 order And my lord, in April, they are examining it for the first time. Is it believable?
Sir, the limitation would start again counting from on and after 3rd of January 2022.
No, my lord, I am,
I'm again saying, if the 60 days period is provided for preparing an appeal, and then if you calculate it from 23rd November to 29th November, if the first day is to be excluded under Section 12 of the Limitation Act, then at least we would come to 6 days there. Then still 54 days were left from 3rd of January 2022, 53 days. If the 53 days is to be counted, they are not supposed to explain during any event during the period of limitation.
not required.
It is only required when
Only
the
the delay.
application for certified copy was applied after the limitation. Then, otherwise not. So even then they said, because if 3rd January is the starting point of the further limitation, then 54 days that would sometimes expire, say in February or in the first week of March. February, it will expire. And then they say that, yes, obviously the March, then you say that there was a limited functioning. And then in April, they took up, they sat, and thereafter the decisions were taken. Everything they have narrated in paragraph 4 and 5.
Yes, well, this is what I am. Kindly see the narration. If this is the quality of narration and lordship gives credence to it, then my lord, in a commercial matter, then my lord, this is worse than even a regular section 5. My lord, kindly see. My lord, I give them the benefit of doubt what is falling from your lordship. Even the Supreme Court circulars are, my lord, up to February 28th February 2022.
After that 90 days time is made available.
Supreme Court, that will not cover, because this is happening in between where below the period had started.
Then again, I say strict interpretation.
My lord,
is a different-
lordship will, I'll come
different
back
issue.
with the circular. They will not be entitled to the benefit of the circular. Because my lord, the certified copy applied for, they have done it and it is covered by subsequent Supreme Court judgments.
My lord,
Now, my lord-
friends, my lord, need not be so apprehensive about,
And-
my lord,
and-
the merits
And
of
my
the
lord,
appeal,
in
if
the
there's no proceedings.
entire, throughout they are participating. My lord, kindly see, my lord, if subpara 3 and 4,
My lord, one thing is, my
It
lord,
reminded me of my days over in my initial days of Justice N.K. Mitra. You must have appeared.
no, my lord, that cannot be a consideration, my lord.
No,
Kindly,
it's
kindly
not a
do not have that.
consideration, just it's a recapitulation of those events.
Kindly,
I am simply inviting your just
Yes,
to
yes. My lord,
recapitulate.
I just restrict myself to page 4, my lord, paragraphs 3, 4, and 5. My lord, I just read it for my benefit. Sometime in April 2022, my lord, kindly see, my lord, the casual approach, para 2 is Omicron is approximately in March. Then sometime in April 2022, legal department situated at Bombay. Who was the concerned officer here? The person affirming it is somebody who is here. Shumit Basu is, my lord, in Kanak building. Is it their case that this department was closed? They were unaware of the order. Any circular disclosed? Then, my lord, kindly see, sometime in April, legal department in Bombay, after examining the order of November, in principle decided to prefer the instant appeal. All right. Several meetings were held between the corporate banking department and legal department between April, 12th April and 18th April. All right. To understand the commercial ramification, primarily in view of the findings, so and so. After such meeting, it was decided appeal should be preferred. So 18th April itself, decision is taken. And I am assuming it is correct. Then also lordship takes 60 days. But otherwise, my lord, Justice Nariman's judgment, lordship has seen. Look, this can't be, my lord, this in a commercial matter, if
I
this becomes a
understand.
precedent, my lord, this slipshod, my lord, excuse, my lord, it will, entire purpose will be frustrated.
No, it is, I understand. When in a commercial litigations, what is required to be done. But still, it does not really take away that so far as the discretionary part of the court is concerned in a section 5.
I'm not saying
I
that.
can understand so far as the litigations are concerned, where certain special period of limitations have been provided, then if there is no power which is conferred, then the
I am
court
not
should
saying there is no power to
But-
condone.
But that is why when the Commercial Courts Act also reserve the power upon the court to condone, then in that event, one has to understand, after all, it is a commercial transaction.
Correct. That is
It
why.
has some impact so far as the economic growth and the development
Lord,
of the
that is
country
why-
is concerned.
That is why, my lord, in the beginning, my lord,
that is
cursorily I
what-
referred to the merits because, my lord, over here,
You are correct.
over here, my lord, in
Ultimately, it may
international
ultimately
arbitration
lose.
interim award has been passed directing BREB to secure the amount.
We still distinctly remember when the other matter came,
Correct.
that what has happened despite the order, what was the conduct of the
what
parties,
has-
we know.
What has
We
happened
are
is, my
aware,
lord,
we are aware.
unfortunately, Citibank, who has now come over here, they were aware of the order from day one. There are letters saying that it appears that BREB, the Bangladeshi concern, is not going to honor that. So we may be forced to part with the money. And after knowing of the order, they have parted with the money, waited for 8 months. And when they now find that they are unable to, my lord, they come in over here. as a-
May I just say one thing? Well, ultimately, at the end of the day, the guarantee was given by the Bangladesh bank. My lord, when the order of restraint is passed, my lord, restraining the bank from, my lord, paying under the guarantee, well, it is the Bangladesh bank which is restrained. Now, my lord, the restraint on, my lord, Citibank, my lord, Kolkata, is, my lord, not to make payment under the standby letter of credit. My lord, we are concerned with that, my lord, today.
My lord, this
No,
appreciation is perhaps not correct.
No, my lord, I'll
In
tell you,
any
Lordship.
in any international letter of credit, my lord, what happens is, if a letter of credit is opened by an outside bank, there has to be a standby letter of credit in the corresponding bank, which is back to back. And my lord, the
Can-
terms, and my lord, the injunction was invocation of the main guarantee. Again, we
Well,
are
That is, my lord,
digressing
why,
on
my lord,
merits.
I cannot, my lord, be held responsible. But, my lord, I am a party, and my lord, what it ultimately
But
sounds
if
in.
this stand is there, since you have not given a bank guarantee and the bank guarantee is given by your, the.
If there is
corresponding-
no order operating against me, my lord, I shall walk away. Let my learned friend record that.
No, that is what he says, that it is there in respect of that. So far as a standby letter of credit is concerned, that will take its own, it has to be interpreted in its own way, or in its own
But
purpose.
I, my lord, have been
And-
able to
and-
understand the
and
order
that's
in the
all.
sense that, my lord, there is, my lord, also, my lord, a violation alleged
Why-
against
why-
me.
Now the problem is they are alleging that so far as the bank guarantee issued by the Citibank at Bangladesh is concerned, there was an restrained order.
But I am held to be a branch office, so, my lord, I am also supposed to be, my lord, in violation. Well, that is, my lord, what is my
Lord,
concern. So, my lord, we did
the-
not know whether, my lord, we have
the-
to appeal against the order or
The
not.
impugned order has been passed on the application of Citibank Kolkata, where it contended it is a separate entity.
That's
And
right.
my lord, that is why the order is there. I am not making submission on merit.
That is why I say, my lord, this is something that has to be decided.
Let us hear out both main and the section 5.
Very well, my lord.
If we do not find any merit, we will pass.
Very well.
Look,
He is there,
that-
but he is to be reminded that as a member of the bar, he has the privilege of both. It's a both sides of the coin. We are alive. That's why I'm not speaking so clearly.
No, my lord, Lordship will decide the section 5. If Lordship wants to go into the merits, I am also.
No,
open.
we'll decide it on merit.
Because my lord, this will set a very dangerous.
No, understand. Let us see. In all probability, in all cases, we have to bear in mind a very generalized proposition of law, that what is required under a commercial, the litigations and in the normal litigations, and whether any segregation, when it is not real, can be made.
Because my lord, over here, there may be some overlapping on some correspondence which
I
pertains to
understand,
merit.
Mr. Chaudhary, I understand. There are certain special period of limitations provided under the Commercial
Correct.
Courts Act. The Supreme Court or various high courts have said that those period of limitations has to be reckoned as mandatory. And if there is any default, there is no question of giving any discretion or something on the court to extend it. But the situation would be where there is a period of limitation and the power is also given therein upon the court to condone it or to extend it. then in that event, you wanted to say that the very strict rule of exercise of the discretion should be applied. Correct. Now we have to understand, we have to decide whether that was an intention. And if that being the intention, then what was the purpose of incorporating that the discretion left to the court to decide?
Lordship will recall in the other matter, my lord, when we had,
One has to understand and one has to decide
my lord,
whether two parameters can be given in this.
yes, my
regard.
lord, Lordship has already considered Justice Nariman's judgment, my lord, in that over here.
No.
Lordship will apply the same test because factually, my lord, this is more gross than even the other one.
Let us see. When both.
Any day convenient to your
No,
lordship.
no, it's your convenience because I do not know whether.
My lord, let my learned friend say, my lord, whenever.
My lord,
Whenever it is convenient to you.
Tuesdays, Thursdays. My lord,
Any day you say that you should come on when I prepared on merit,
yes, my lord, of course.
both of you.
Ninth is a holiday, no? Well, if your lordship takes it up on, my lord, 11th of May, my lord, that's a Thursday.
I don't mind if both of you.
শেষ হবে না?
11th it's all right, but thereafter, my lord, I may be in some day. 11th is all right.
11th. Let both the applications as well as the appeal be listed on 11th of May 2023. It is made clear that the arguing counsels shall make the submissions not only on the delay in filing the instant appeal, but also on the merit of the said appeal.
It will be final. Very final.
हाँ,
Trial होएगा सर.
Presided matter. Item number 1.
My lord, in the first three items, 1, 2, and 3, one has been called on. But I am appearing on behalf of the administrator, my lord, appointed over Stray Infrastructure. Copies of the petitions were served by email at 9:43 p.m. yesterday, intimating that it would appear as item number 1. I'm certain, my lord, it was filed, my lord, at least 2-3 days back.
no, this matter appeared when? Yesterday or day before yesterday?
These three
First
matters
time,
have not
for the
appeared,
first time.
subject to correction. These three item numbers 1, 2, and 3 have not appeared before, subject to correction.
And it was served on the client. From client, it came to the advocate on record later.
All it was served purely as a courtesy, my
Is
lord.
this,
They are not on
what is
caveat.
this?
It's
the
my,
appeal?
I thought it's my duty to point it out.
No, that's true. That's true.
Sir, please, it was served on the advocate.
When?
No.
When?
No.
I am on time.
No, you
I am
said
on
it was
time.
Served on the advocate.
I'm on time. I did not say it was not served on the advocate.
You said it was served on the client, not on the advocate.
Yes.
It was served on the advocate.
The appeals are in any event defective. Because on the last occasion, when Odisha slurry matter my lord, was dealt with your lordship, this is the order that my lord passed on 28th of February 2020.
What? What?
It has been filed as FMAT.
We are sticking to that, my lords. That day, there was a consent given by another appellant. But that consent, my lord, will not be a precedent for today.
So your lordship may please settle the question of law.
This is FMET. And this is against what?
Lord, there
Rejection.
was an order of
Order.
19th January.
Rejection.
Same order.
Rejection of the claim.
So it has to be classified as first appeal.
My lord, with the utmost of respect, my lords,
Yes.
what has happened is that there has been a rejection of the plaint, not a dismissal of the plaint.
But it's still a decree rejection.
My lord, with the utmost of respect.
Within the definition of a decree under section 2 of the Code of Civil Procedure.
My lord, if your lordship.
If it is a
recall-
decree, then you'll have to, look at it. Rejection is included in the decree, not a deemed decree. It's a full-fledged decree.
My lord, in essence, this is a return of plaint. This is not even a rejection of plaint, this is a return of plaint.
You just said rejection of the plaint. That's why I reacted.
I
to it.
apologize, my lord. I further
I
correct
reacted
myself.
to it because if you look at the definition of a decree,
My lord.
it's an inclusive, means an expansive definition and includes the rejection of it. Your
But if you
junior
look-
has shown.
But if you're,
You got it? The definition
my lord,
includes the rejection of plaint.
my lord, but here, my lord,
Wow.
actually it was more of a return of plaint. I'm so sorry for having
Let
used the
me,
wrong
but
word.
there is no question. If 12A gone, then party automation says no concept of return, reject.
My lord, may I respectfully submit, my lord,
Reject.
what has happened here? Basically, he has said that return.
No, the application is rejected. The plaint is rejected, sir. What are you saying, sir? If you come to the internal page,
That may be,
page
my lord,
53,
question is
from
not,
the aforesaid delineation, the application being IA2 of 22 is hereby rejected. In consequence thereof, the plaint in the instant money suit is also rejected. So it's a rejection.
my lord, may I
It's a
respectfully submit?
rejection. No,
My lord, may I just respectfully submit an argument for your lordship's kind consideration?
unnecessary.
My lord, just please,
When on the face of the record,
just please.
it appears it's a rejection, so it has to be classified as FE.
My lord, may I respectfully submit, my lords? If the trial court has erred in using a label, would your lordships be bound by the same label? My lord, with the utmost respect.
Ultimately, we may hold otherwise that you should not have been given this level, but on the face of the level, we have to classify the appeal.
My lord, but
We have to classify.
what I am in effect challenging, my lord, is also a rejection of my, in the second. and-
12A leave.
My lord, may I explain what has happened, my lord? These three appeals are slightly different. The first appeal, my lord, is by a defendant. It is not by a plaintiff.
Let the classification be done and let us see. Can't be done in this way because it will attract the court fees. And
My
a
lord-
court fee is a matter between a court and the appellant.
My lord,
1961 Supreme Court.
My
They
lord-
have no role to play. They can't, sir. We are concerned with the court fee and this 100 court fee
my lord,
is
may I
not
respect,
justified.
my lord, may I respectfully submit one thing, my lord? Litigation is not supposed to be a source of revenue for the courts per se.
Then what is the necessity of incorporating Court Fees Act?
I'm coming to that, my lord.
Uh,
Please allow me, my lord. The court fee for an appeal has already been paid once by another appellant. How many times, my lord, would the appellate court require
uh-huh.
the same amount to be paid again and
Then-
again and again
then-
and again and
then
again?
Then the Court Fees Act has to be amended because it says that when an appeal is filed, the appeal would attract the court fee.
Well-
And the court fee either on a ad valorem basis or on a fixed basis. So
What?
far as the FMET is concerned, we have we have said that it's a fixed court fee. So far as the regular appeal is as ad valorem on the basis of the value.
My lord, but your lordship has
But
the
still
power.
you are lucky in West Bengal
I admit, my lord, I admit.
because there is an outer maximum cap which is given. In other states, it's on the basis of percentage.
My lord, but may I respectfully submit, my lord, your lordship would have the power to read down the Court Fees Act,
No,
that where the phrase says the appeal means all appeals.
we can't. All appeal means any appeal.
That's right. So if
Which
there are
is-
multiple appeals, my lord, one appellant paying the court fee is adequate. It meets the spirit and
There
letter of the
cannot
law.
be a multiple appeals. Kindly visualize. If there is a final decree which is passed, then it is a one appeal which comes before the appellate court. And if any orders which are passed and an appeal comes, then the legislature has taken care of that and then imposed a fixed court fee that you need not have to pay the entire court fee leviable on the basis of the valuation of the suit as a ad valorem court fee. No. it has been fixed because the legislature were conscious that there may be many orders which are challenged before the higher forum. Every time the ad valorem court fee is paid, no, it will be a hard on the litigant to do that. So that's why it is really a decree. Then it is against a decree, one has to pay.
May I just pause for a moment? Lord, as my colleague is trying to remind me, my lord, what has happened here is that, my lord, the learned trial court has done two things. Number one, it is rejected in appeal 2 and 3. 2 and 3 is slightly different from appeal number 1. As my lord can see, my lord, it seems I'm quite out of desperation. I'm trying to argue, but let me try. Let me try. Allow me a fair shot. There are two things that have happened here, my lord. Firstly, my lord, in appeals 2 and 3, an application for impleadment has been also consequently rejected. My grievance is essentially against that as well. So that, my lord, purely qualifies as an FM80. I'll repeat, my lord. In appeal number 2 and 3, the appellants before your lordships are parties who had sought impleadment in a representative suit. The suit before the learned trial court was an Order 1, Rule 8 suit.
Was any leave sought?
It was pending. It was one of the many applications pending, and all wholesale were rejected. But whether leave granted or not granted, my lord, the prayer in the plaint was in the nature of a prayers in a representative suit, and that cannot be taken away by a decision of the court not taken. That can, let me rephrase that. That nature of the suit cannot be taken away by an order not yet passed by the Honorable Court, which is in any case eventually to be passed. It ought to have passed. So because it is not passed, will not alter the character of the suit. It's a representative suit.
Ultimately, rightly, wrongly, whatever is, the plaint came to be rejected. Now there is no less which you can say pending before the court.
My lord, suppose I'm challenging the word rejected. Can I be asked to pay the court fee as a consequence of rejection and then get a correction of that? My lord, it should work in reverse. Your lordship should take an undertaking from me that if I fail in challenging the label rejection, then I'll be liable to pay the full court fee for an FAT.
It's a court fee. If the court fee is not paid, there are provisions under the code as well, which says that the court may reject. Suppose the court extends the time to deposit the court fee, and the court fee is not deposited, then it is one of the incidences where the court will reject the proceedings. No difficulty. Even under Order 7, Rule 11, it has been incorporated. If you do not pay the court fees, when a court has extended the time, it's also a ground for rejection of the plaint. The court will not enter into the merit. Similarly, if the analogy is to be drawn, if there is a court fee which is attracted or leviable on the appeal, then the court will definitely will say 61 Supreme Court I just referred, where the defendant wanted to interfere on the court fee. The court says, you have no business. You can't come. It is a matter between a court and the appellant. It is the court which will see that the court fees are paid.
Well, but this court fee
in that event, if the court finds that the court fee is leviable, it is to be paid, then it is to be paid. So far as the orders are concerned, you are aware what remedy is to be done.
Well, that's what I'm trying to respectfully. First, my lord, the issue is this an FMAT or an FAT? The earlier order, my lord, was a consent order. That cannot be a precedent.
No.
In the other matter, my lord, your lordship would recall.
We are going to decide it on a definition of a decree. If on the face of it, whether rightly, wrongly, whatever, informally, the court has used the word rejected. But as long as the word rejection of the plaintiff stands, it has to be classified in that way, and the court fee would be attracted. Ultimately, the court may interfere with the order. We don't know. The court may ultimately interfere with the order and can set aside the order and say the rejection was not justified. What the appellate court does, reverse the decree.
My lord, may I give an example, my lord? Suppose, my lord, the issue before the trial court was whether I'm a man or a woman. And the court fee for a man is 100 rupees, court fee for a woman is 10 rupees.
It's a discrimination.
Allow.
Constitutional bar. on a gender basis, you can't make a distinction or differentiation. No, you can't.
Bad example, my lord, bad
Uh,
example.
Can't do it.
Suppose the issue was that a senior citizen is 10 rupees and a non-senior is 100 rupees. And the trial court wrongly classified me as a non-senior citizen. And I am aggrieved by that very finding. Now, it's my respectful submission, my lord, that the issue of what court fees should be paid by me, who is a senior citizen, should be at the end of the appeal, not at the, because that is the very issue I'm appealing.
Section 11 of the West Bengal Court Fees Act. It permits the court to make an inquiry as to what the court fee would be leviable on this. And it's a paramount duty, mandatory duty of the court to do that. If you look at section 11 of the West Bengal Court Fees Act.
My lord, I will also urge
So
before your
that is-
lordships.
That is what is, we can't postpone this particular aspect of the court fee to be decided. It's not a partition suit where court fees are actually paid or the entire thing is
Lord,
paid.
I am on the point of justice. Then your lordship,
We
could
can't
consider.
rewrite the law, nor we can override the law.
Very well.
Because the
Then your
law as
lordship-
it stands
Then your
is-
lordship could consider that we'll file a 148A application seeking deferment of payment of court fees by 8 weeks or the date of disposal of the appeal, whichever is earlier. 148, I believe. Or what
It's an extension of time.
Extension of
That's provided under the code.
My lord, with the
It's
utmost,
not a code.
my lord,
It's
with
not
the,
provided under the code. It's the Court Fees Act.
my lord, with the utmost respect, time for paying court fees is routinely granted.
Not
At least
always.
in Delhi, my lord, it is routinely
No,
granted.
everywhere it is routinely granted. Even here is the plaint is admitted subject to an undertaking given by the learned advocate for the appellant to put in the court fee within a time frame.
Correct.
So,
So I am saying, my
but
lord,
the
8
court
weeks.
does not really proceed. They're dispensed with. That
No,
it will be decided at the time of final hearing.
no.
Never done.
No. I'm not. Let me rephrase, my lord. Maybe I didn't make
So
myself
that's
clear.
why what we intend is let it be classified as a FA, and we are extending a time, no difficulty for putting in the court fees. You put in the court fees, let it come before us, no problem.
My lord, may I
It's
respect?
the only thing I just want to say.
My lord, may I also protest against this classification, my lord, because I, in appeal number 2 and 3, I am more aggrieved at my dismissal of impleadment leading to dismissal of interim
By
relief.
this order,
Yes, but my lord, but please see the latter part. Please see the last line of the order. He rejects all pending applications also. Rather, he dismisses them.
so where
One is my impleadment. So I would have no remedy unless your lordship first decides my impleadment. That do I deserve to have been impleaded in the suit? So that would be an FMAT, my lords.
you have
Beg your pardon?
you have the remedy.
I have, my lord.
Remedy.
Your lordship would please spell out the remedy, my lord, if it is not before this court. I mean, I believe it is before this court.
Obviously, this much hint I can give.
So, my lord,
No problem.
so, my lord, if that be the case, my lord, the label of the appeal may kindly be ignored. And my lord, kindly see the irony, my lord. What is this appeal all about? To get over the hump of 3 months.
Now I give you a link.
My lord.
Suppose several orders have been passed.
My lord.
And ultimately the decree is passed. And a challenge is made by way of an appeal against the decree.
My lord.
Whether the litigant who is also aggrieved by an orders passed in the proceedings has to suffer, has no remedy. If those orders have an impact on the ultimate decree,
My lord, he can file the appeal, my lord, which is what we've done. But if we made an error of labeling, your lordship may kindly correct that labeling error.
that's why I was not saying so. That's why. Now I can give you, there's no doubt about it. Look at section 105, subsection 1 of the Code of Civil Procedure.
5, subsection 1. Exactly, my lord.
So what is a necessity of separate?
So therefore, my lord may
So
kindly.
that's why you can. There's no difficulty that you are debarred. So let it be listed here. Let it be classified as first appeal and then.
But my objection would be to the court fee, my lords. My lord, the principle of unjust enrichment will also kick in. My lord, suppose there are 50 appellates.
You have not challenged the vires of that, where the court fees are very categorical. In an appeal against a decree, you'll have to pay the court fees according to either the valuation of the suit, or if the part relief has been granted, then the relief which has been refused on that basis is a very, very reasonable way of doing. Suppose in a money suit, a decree for 50 lakhs was claimed. The court granted a decree for 25 lakhs. The plaintiff is aggrieved by a refusal to pass a decree for 25 lakhs. Whether he is required to pay the court fee for whole of the 50 lakhs? No. The act is very categorical. Where you are aggrieved means on 25 lakhs, you'll have to pay the court fee. Only because 25 lakhs you succeeded.
My lord, if your lordship would recall the last argument, my lord, the last time that we
That
were
is
here.
what I say,
your lordship did not
classification, let
want
it
to-
come. Classification, let it come. No difficulty. And then think of that.
But your lordship had said, my lord, that your lordship does not like this precedent. If the last time we were here, my lord, when Mr. Saha was objecting to this very issue, your lordships expressed unhappiness at the objection, which will impact a lot of litigants who are being made to suffer on account of a brazen, blatant misappreciation of the law.
The difficulty sometimes it so happened because of in every FMA, it so happened like that. But still, I tell you, now we are live, we can't express, but something is to be done in this regard. So far as FMA is concerned, means rejection of plaintiff is concerned.
Lord, at the end, my lord, we can only appeal before your lordships with folded hands for justice. All these doors, my lord, numbered door number 98, door number 552, they're all doors to get into the main room.
You may be right to some extent, but the law as it stands is a difficult proposition.
My lord, then your lordship may kindly be pleased to, my lord, proceed with the appeal today by holding that it will be treated as an FA and the whole registry will sort out the thing and record my undertaking, my lord, that I'll pay the deficit court fee within 4 weeks. But kindly proceed with the appeal. I'll pay the deficit court fee within 4 weeks. That's permissible, my lord, under 148. My lord, please see the irony, my lord. This whole issue is 3 months of mediation. We spent 7 months before the learned trial court. In fact, my lord, I will pitch my appeal so high as to say that the trial court is in contempt of your lordship's order of 9 December 22. Contempt. He chose, my lord, to follow an order of Madras High Court in preference to his own division bench of the Calcutta High Court. Now, I could do it in another way, my lord. I could file a contempt petition instead of an appeal. And your lordships would hold in the contempt proceeding that this order is contemptuous and therefore void. So, my lord, but I don't want to go there, my lord, because we have to go back to the learned trial court. But please appreciate the sensibilities, my lords. Actus curiae neminem gravabit, my lord. Can a party be made to suffer for an act of error of the court? Here, he ought not to have said that the plaint is rejected. He ought to have said that the plaint is returned to be represented. In fact, he says so, but in not so many words. He says you come back after 3 months. In other words, you come back to the right court. I'm returning you the plaint. You come back at the right court after 3 months. Which is the right court? My court, but not today. Today, my court is not the right court. After you finish 3 months of mediation, my court is the right court.
That's the wrong approach if he returns or keep the matter pending.
My lord, that partial automation will need to be read down a little bit, my lords, with due respect. My lord, please see, my lord, my suit.
I think a Bombay judgment was criticized. That's a
Yes.
Bangataro.
Yes,
or what is this? Bangataro or
Gangataro.
Gangataro. That was criticized that you can't keep it like this. You go, I'm waiting, you come, The courts ultimately held that there is no other option but to reject the plaint. If it appears 12A violated, nothing can be done.
May I pitch another
Then-
argument, my lord?
Then,
If
then-
my
then
order is
we have held also in the same line. And once the rejection, please get it classified as FA, because the order, if it is dictated today, that would be recorded in an FMET, and there will be another problem in the CIS.
But would your lordship be pleased to consider my request, my lord? As it is, commercial court convenes twice a week, my lord. And many times matters that are listed for want of paucity of time cannot be heard. If your lordship may be pleased to hear the appeal with direction to the registry to convert into an
No,
FA.
it's not like that,
and-
because hearing of the appeal in that particular truncated manner should not be done, because for what reasons? Because there are many litigations which are really pending before us. So we have to give equal opportunity in all the matters. Because this one matter takes a longer time, then the others are really suffering. They are suffering. So that is what it has come. Let it come on Tuesday. We'll definitely consider, and we'll consider on the prayer for interim prayer. We'll hear out the appeal later on, but we will definitely consider
For
the
the
interim.
interim prayer, I do not know if it will, I mean, if your lordship stays the rejection, I do not know if the trial court will then proceed
No,
with, so my lord, therefore the interim prayer would be of no meaning in this particular case. My lord, please see the irony, my lord. You
Ye-
stayed 3 months of mediation, learn in trial court, spend 7 months. My lord, please note this, your lordship is heading the commercial court.
True.
47 hearings. 47 hearings, averaging 2 hours each. 94 hours, my lord, are spent on deciding whether or not to allow 12A. And then he followed the Madras High Court judgment in greater deference to your lordship's own judgment, which is crystal clear. And then, my lord, from January till today, another 4 months have passed.
Do one thing. You put in by Monday. We are fixing this matter on Tuesday, because this is an interesting thing which has come out. If those are correct, that the Madras High Court judgments and the Calcutta High Court judgments, if are taken together, then which one
Only
is to
difference was
follow?
this, my lord. Madras High Court says that you must examine the application for interim relief to understand whether or not it's a bogus, whether it's a bogey, just to get over 12A. Whereas the lordship said that this is a problem in the act and it's for legislature to intervene. But for now, we will proceed that there is an application for interim relief. You have to blindly allow 12A. It's another matter that when you take up the application for interim relief, if you find it's a bogey, like what Madras High Court does, then levy heavy costs. There's no limit in Commercial Courts Act. It's not the CBC.
So let us hear out in that way on Tuesday. All the councils are here. Let them come and argue on that. But first, cross the hurdle of classification.
But he's saying that the label is rejected, so that's a problem. Kindly see para 24 of the impugned order, my lord. The label rejected or returned, please see, my lord. And I will invoke actus curiae. If he has said rejected instead of returned, I cannot be made to suffer.
No, he has said rejected.
That's what I'm saying. He should have said returned. Please see para 24.
Return is wrong.
My lord,
Return is wrong. Then again, they would come
my
and
lord, may I explain?
and vociferously
May I
argue like
explain, my lord,
you
why party?
with a persuasion that no, this
No,
is
may-
against the party automation.
Well, may I explain why partial automation does not apply here? Partial automation applies when you filed a plaint, it has not been registered as a suit. And at that stage, Supreme Court said, no, you will not keep it pending, return the plaint. In my case, it was registered as a suit.
That is what he say when the leave, what the ultimate decision in the partial automation is. Two situations. The situation A is that where the suit has been registered without invoking section 12A, and then the suit was allowed to continue, interim orders were passed, then the partial automation says in those situations, the court will consider one thing, whether the jurisdictional high court have earlier declared this provision of 12A as mandatory. If not, then in that event, the court has said that this modalities has to be adopted
For future.
future, where the jurisdictional high court has already held
Correct.
that the provision is mandatory, then there is no other option but rejection. You have to go. Our high court has already declared much earlier than this party automation and says that the 12A is mandatory. So in that event, we say that any proceedings which are there, that has to fall.
My lord, but mandatory if there's no application for interim relief. This order, my lord,
I
is
have
not an
then you
error
have
in the
not
exercise
understood my
jurisdiction.
judgment. I said application for urgent interim relief is not a determinant factor. It is whether the suit contemplates an urgent interim reliefs,
My lord,
because that is the language of section 12A.
course.
I have still doubts. Suppose there is an urgent interim release. That's why I say that the legislature has to think of it.
My lord, the difference between a suit
And
and a
ultimately,
plaint
court does
is
not find
literal,
it is
my
an
lord.
urgent
My
interim
lord, a
release.
suit
Court will
includes, my lord, a suit includes the pant and the waistcoat, my lord. And that in context, I mean, the plaint plus accompanying application is what comprises
Why
the
not
suit.
tuxedo?
My lord, may I have your lordship's leave, my lord, for a short while? May I have,
No, we are keeping it on Tuesday unnecessarily. Let us see. Yes,
may I have your lordship's?
please. Are you serious in this, or you're not serious on this FMAT? Because you have.
The law, either way, will have to be settled. Your lordship was considering another matter even after your lordship's earlier judgment.
Well, there's one more aspect of the matter, my lord. Whenever a suit is not proceeded with, like in this case, those court fees have to be returned. I have a Supreme Court judgment on that point. Though the point in that case was return of plaint for presentation to proper court. But it also applied to Order 7, Rule 11. My lord, because unjust, my lord, court cannot, my lord, with due respect, court, my lord, with due respect, my lord, this is not a court tax act. It's a court fees act. And your lordship is well aware, my lord, the distinction between tax, cess, and
I
fee.
know, and I am conscious of tax, fees, cess. I am conscious. You are trying to say the fees has to be calculated on an actual expenditures which are to be made and dependent upon all the factors, whereas the tax, it is a domain or an exclusive powers of the sovereign to impose it, irrespective of what. So these are the distinction which one has drawn. But court fees is a different, because here 47 dates have been invested. Yes. After perusing the no. After perusing the tenet and the nature of the impugned order, challenge in the instant appeal, we find that in effect, the plaint has been rejected. And in view of a definition of a decree under Order 2, Rule 2 of the Code of Procedure, the rejection of plaint amounts to decree, and therefore the instant appeal has to be classified as FAT instead of FMAT. The office is directed to reclassify the appeal in view of the observations made here in above. Leave is granted to the appellant to put in the definitive court fees by Monday, date the other. List the matter on Tuesday.
My lord, if your lordship would kindly observe, my lord will be filing a section 148 CPC application for consideration. My lord, allow us to be heard, my lord, allow us to get courage from our success, and we pay the court fee in our mind, keeping in mind there's a donation to the system rather than actual requirement in law. Because one of the appellants, my lord, is in Canada.
Does not apply.
I was just looking at, because I had a bad habit of going into the provisions one again and again. That is what I learned from my seniors, and
So let
let us see.
Your lordship, but I just wanted to point out 148 has no application.
One 149, my lord. 148 or 149.
Yes.
And 149, my lord.
No. I have read 140. 148 does not really apply in that sense.
My lord, if your lordship were to direct me to pay court fees with the reclassification, then I can also invoke 148, independent of 149.
That is a different aspect, because the court directed you to do a certain things within a time frame. Then, so if you do not pay by Monday, then
That's what I'm saying, my lord. So if your lordship were to,
but at this stage it does not. But
Lord, consider-
149,
my lord, your
149,
lordship's court has
yes,
always been a very
definitely.
broad-minded, justice-oriented court, my lord.
No,
I
that's
simply
true.
request.
You are correct to some extent. 149.
Very well.
So come.
149 is against it. 149 is.
No,
against
it says where the whole, please, where the whole or any part of any fee prescribed for any document by the law for the time being in force relating to the court fees has not been paid,
Right.
either wholly or partly.
Right.
The court may, in its discretion, at any stage, kindly visualize, allow the person by whom such fee is payable, that is a plaintiff,
Right.
to pay the whole or part, as the case may be, of such court fee. And upon such payment, the document in respect of which such court fee is payable shall have the same force and effect as if it has been paid at the first instance.
Therefore, unless the fee is deposited, the document will have no effect.
No, it is, kindly visualize
Part
two
fee is
things.
already deposited.
Two things, where it says that either in whole or in part. And the word, this is the such payment. Such payment must be referable and relatable to the earlier instance, where the court may direct either the whole or in part, the court fee has to be paid.
And then you got the last part, and
The
upon
last
such
part,
payment-
upon,
such payment,
that's why the such has to be interpreted in this way.
upon such payment.
Such payment means either payment of the court fees in its entirety or part.
So, Lord, kindly see.
How, read, where the whole or any part
Yes.
of any fee prescribed for a document by the law for the time being in force relating to the court fees has not been paid. Stop. Either wholly or partly not paid. Then the court may, in its discretion, at any stage, allow the person by whom such fees payable means, such fee means court fee
Yes,
is payable, means total.
Correct.
Then it says may allow to pay the whole or part, as the case may be. So it does not say the whole
correct. Of
Part.
such court fee.
of such court fee, and upon such payment must be either whole or a part.
Right.
That is what I say.
So,
But
but
here,
here,
only when, my lord, there is a part which remains unpaid. My lord, that part would then be.
It has to be paid later on, but 149 says that at least the document would be taken into consideration.
Document would have no effect. It will be a stillborn, my lord. appeal.
No, my lord, that's not. My lord, I will show your lordship umpteen judgments of High Court, Delhi. 2 lakhs is the entry fee.
Delhi.
I'm
We
just giving
have, we have
There you
our own judgments.
Not in any event, this
Or a Supreme Court judgment is also there.
consider lot 149 of the next day. Let's see.
Let him make an application under
Please,
140. to
please
140.
come with a 2012,
Would
12,
have, my lord, I'm informed.
2012 volume 4 SSC.
My lord,
please.
firstly, it's between us and the Honorable Court, my lord. They can't turn into a list.
2012 volume 4 SSC. I think it's a Nawab John.
2004.
A or B Nawab John, I don't know.
My lord, why are they so hell-bent on driving us into penury?
I think there is a such, I believe in 2017
I'm
judgment. is
aware of
also
that as
there.
well. I'm saying you're driving me into penury. I'm not saying I'm penurious.
Once you are in penury, you can apply.
Yeah, but I've not yet been driven into
I think,
penury yet.
if I'm not wrong, A or B or C Nawab John, I do not know, first letter. Probably 2012 volume 4 SCC, if I'm not wrong. Now my memory is betraying me to some extent.
12, 7 SCC, 7.
Correct. What is that? John, Nawab John. A Nawab. That's why I say A, B, C. I do not know what is that. And there is another judgment of 2017, if I correctly remember.
My lord, my learned friends are making too much of a mountain out of a molehill.
Come on Tuesday. Let us see. 149. We'll consider on that day. Come. Yes. Yes, call the later.
My lord, I could participate by video conferencing if your lordship allows, my lord, on Tuesday. May I participate by video conferencing?
Oh, always welcome.
Very well.
Even when there was nothing, we always permitted everybody to come. So now the resolution has been taken. We can take.
But much obliged.
Yes, come.
Item number 2, 1, 2, and 3, my lord, will.
I think
Same
2
order.
and 3, I have indicated him what to do. I do not know what he will do. This is against the part of the order.
Yes, please.
It's the same.
Think of. We are simply making it not today. Think of.
Very well.
Item 3, consider 105(1). Yes. Same. Same matter.
2 and 3, my lord, is against the same,
Yes, same
order.
Just not today, so that it will appear on Tuesday along with that.
For the court's opinion also an application has to be made. For the court's opinion also an application has to be made.
I do not know. Not application. It's not application.
It's not for the suit. In the original side, but my lord, it is ultimately for the court's opinion. Okay, originating summons.
Which one? I could not follow.
Originating summons suit.
Yes.
Right for court's opinion.
After all, it is a law which has a primacy. After all, we are all the subservient of law. So let the law be decided as it stands. Yes.
2, 3, and 4 minutes all on Tuesday.
No.
1, 4, 2, 1, 2.
Yes. 4.
Item 4.
Make this, Your Lordship. Item 4, my lord, I am appearing for the appellant. My lord, my lord, on the last occasion, we had tendered unconditional apology. My lord, we have put it in statement, my lord, in the supplementary affidavit. We have served the supplementary affidavit.
Who is appearing for the other side?
Beseech Your Lordship, my lord.
What is this application?
My lord, it's an appeal. Your Lordship will be pleased to recall, my lord, it's an appeal. There was a delay of 85 days. My lord, we had
Section 5, say so.
5, my lord.
Section 5, yes.
Yes, my lord, there was a
Maybe have, my lord,
allegation against the lawyers, my lord. We already served the copy already supplementary.
my lord,
affidavit
may I
has
have, my
been
lord's kind leave to file the supplementary affidavit, my lord, by which we have tried and explained, my lord, the submissions which we have
What do you
made.
say? Section 5,
185 days is delay,
85 days.
my lord.
So what do you say?
I leave up to your lordship.
Give it supplementary.
This is the application seeking condonation of delay in filing the instant appeal beyond the statutory period provided therefore. On the last occasion, we find that the amendments made in the application for condonation of delay was scanty, as further explanation was sought by way of a supplementary affidavit. The supplementary affidavit is filed today. It is indicated therein that immediately the order passed under section 34 of the Arbitration and Conciliation Act 1996 by the court below. The instruction was given to the learned advocate who conducted the proceeding to draft the memorandum of appeal and forward it to the appellant, which in fact was done on May 1, 2022 with the electronic mail. It is further indicated that the collation of the various documents was required, including the certified copy for the preparation of the memorandum of appeal. And in fact, there was some dissent on the payment of the professional charges, which led the delay in filing the instant appeal. We find that the explanation so offered is satisfactory, and the appellant was prevented by a sufficient cause in not preferring the appeal within the statutory period. Accordingly, the application is allowed. The delay in filing the appeal is condoned. The office is directed to formally register the appeal. Let the application for stay. What is that application for stay? Can 1 or a can 2?
It's can 1, my lord.
Stay is can 1.
Can 1, my lord. Can 1 of
Let
2022.
can 1 of 2022 be listed on next Tuesday. Yes.
My lord, may it be. Second. It may be on the 4th of May, my lord. I beseech your lordship, my lord. Lord, 4th of May, my lord. 2nd of May, my lord. I'm
4th. Yes. 4th.
Yes,
4th.
F5.
My lord, I had on the previous occasion, my lord, made my submissions and then handed up a written note to your lordships. I had, my lord, briefly indicated, my lord, the broad heads in the note, my lord, without however, my lord, placing the documents or, my lord, the citations that have been referred to in the note. And, my lord, I had, my lord, your lordships had, my lord, indicated that if your lordships have any query on the note, your lordship will call upon me. My lord, may I just, my lord, before my learned friend starts, briefly, my lord, direct your lordship's attention to the note.
That you have already placed.
My lord, I had, my lord, argued, my lord, then, my lord, shown your lordship, my lord, the broad headings, my lord, on which, my lord, I had argued, my lord, the legal, my lord,
We have
propositions.
gone through it. Let us decide then.
Very well.
What is the necessity?
The only thing is, my lord, in reply, my lord, I would imagine my learned friends would confine himself to the note because, my lord, we have dealt with the judgment.
Absolutely, we will not. We have already indicated on a proposition of law, nothing more than that.
Yes, my lord, I'll just on that note. My lord, I'll be very crisp. I'll just follow the written script. It's hardly 10 pages, my lord. At 1 minute per page, I should be done in 10 minutes. Maybe less than 1 minute a page.
Yes.
My first 3 points, my lord, out of my total points are basically on prima facie case, balance of convenience, and irreparable injury. Now, as far as prima facie case is concerned, my lord, this case is a little unusual in the sense that all I have to show is the following 4 things, my lord, that I've shown as A, B, C, D. I have to show there's a contract of guarantee. I have shown that. B, I have to show that the statutory provision in breach of which the guarantee has been issued. In this case, I have shown, my lord, regulation 5.13.2, read with section 143. The third, my lord, I have to show that the statutory provision contains a prohibition and not a restriction. Meaning, number one, it is not certain that the permission will be granted post facto upon payment of some pre-specified fine or penalty, meaning a levy, which is more in the nature of a fiscal measure. Number two, my lord, acting in breach does not involve levy of merely a fiscal penalty that is uniform for all persons in breach, but varies for breach to breach, depending upon application of mind to the particular circumstance. Third, my lord, it could also very well result in a refusal. There's no guarantee that on the WBRC will grant me permission. Therefore, my lord, it is clear it is a prohibition. It is not a restriction like lease deed transfers and such like. Moreover, my lord, in the item D is my fourth leg. I have to show that I am not just under theoretical punitive consequence. I have to show that I'm facing imminent consequence, which is WBRC has started show cause notice proceedings against me. So I'm not in the zone of theoretical damage. I am in a zone of potential damage. So this is why, my lord, I have argued that this is what transforms what is my cause of action, which is the WBRC show cause notice, itself into a prima facie case.
Yes.
And then, my lord, at the bottom, I've compared the two judgments. One is on prima facie case and one is on cause of action. And the prima facie case, my lord, though it is Nirmala Jhala, it relies on Martin Budd. The court said, my lord, a prima facie case does not mean a case proved to the hilt, but a case which can be said to be established if the evidence led in support of the case were to be believed. While determining whether a prima facie case has been made out or not, the relevant consideration is whether on the evidence led, it was possible to arrive at the conclusion in question, and not whether that was the only conclusion which could be arrived at on that evidence. Now, my lord, in my case, it is very clear that because I have been issued a show cause notice, it is possible that my license will be cancelled, I will be visited with severe punitive consequences, and so on. That being so, my lord, my cause of action is my prima facie case, because I have shown the show cause notice. If I had not shown the show cause notice, my lord, I may have had other causes of action, but I may have had a slightly more uphill climb to show that I am a prima facie case. But here my cause of action is my prima facie case.
Yes.
Then, my lord, the second point was balance of convenience. My lord, there are two very simple situations. If injunction is granted, but eventually the suit is dismissed, because that is their argument, that if you grant it today, but the suit is headed for dismissal. Very well. What is their injury? That if it takes, let's say, 9 months to take the suit to closure, because my injunction is not for the next 20 years. My injunction is only for the duration of the suit. It's a commercial suit. I'm quoting Sri Vishnu Construction, the Supreme Court, which said that all commercial suits must be concluded within 1 year. Therefore, let's say that your lordship direct the commercial court to finish within 9 months. In 9 months, my lord, at best, their interest rate of 10% will mean that my liability will increase by 7.5%, equal to 9 months out of 12. But similarly, my lord, my real estate prices may also increase. So where is their injury to them? Whereas if your lordship looks at, if the injunction is refused, but the suit is eventually decreed, though this is the wrong phrase, my lord, is eligible to be decreed, I will not enjoy the benefit. In fact, the suit will never be decreed if the IBC proceedings proceed, because the RP will be appointed, then he has to pay for the company. There is no way, my lord, that the RP can be relied upon to put up a proper pursuit of the suit. So therefore, the conclusion is clear. My suit will be dismissed. If the suit is dismissed, my neck is already on the chopping block, my lord. Then what benefit can I enjoy? Unless I'm protected temporarily. So I suggested a solution, my lords. Item C on page 3. Your lordship may direct that my injunction will remain in force for 9 months or till disposal of the suit, whichever is earlier. And your lordship may direct the trial court to finish my suit, my lord, within 9 months. I am relying on Sri Vishnu Construction, my lord. I have attached the judgment at page 44. If your lordship may kindly see, and the relevant portion, my lord, is page 46 at the bottom. In that view of the matter, we request all the Chief Justice of the respective High Courts to ensure that all pending application under section 11.5, 11.6 of the Arbitration Act and any other application which are pending for more than 1 year must be decided within 6 months from today. But your lordship will just go back to the previous paragraph, my lord. This said that arbitration matters and commercial suits have to be wrapped up within 1 year. Kindly have, my lord, at the top.
Yes. From the left-hand side, page 45, bottom.
Yes, my lord.
I've seen that.
I'm so grateful, my lord. So, my lord, if your lordships, I think this would be a very fair balance between the parties, my lords, that since I have made out a cause of action, even the trial court agrees, and my cause of action constitutes my prima facie case, I am showing the balance of convenience in my favor. I am showing that I will suffer irreparable injury if my injunction is not protected, unless they undertake to defer IBC proceeding. Then, my lord, I don't need an injunction. Way IBC.
Yes.
So, my lord, that is the suggested remedy. Then, my lords, I raise a parallel point on balance of convenience. Are the lenders remediless, my lords, if the suit is decreed favorably? Not at all. Their problem, my lord, is that if my argument is upheld that the contract of guarantee is void because prior permission was required, then the lapse lies with the LLC, the lead lending counsel. Because he opined to the lenders, he provided slanted and doctored opinions showing that I can give this guarantee without prior permission. Like in America, my lord, they may sue the LLC. So they're not bereft of remedy. In America, England, it happens all the time, my lords. The third point, my lord, was irreparable injury, my lords. I don't need to dilate. If they proceed with IBC, I will not exist. Moreover, my lords, I've highlighted in the note, because they refer to my balance sheet, that I have regulated assets, non-regulated assets. That is my classification. Suppose WBRC does not agree. Suppose WBRC says that everything is regulated asset. Because your regulated assets are not only for electricity distribution. Your regulated assets also include assets that are required to be maintained by you as a buffer to support your regulated business. So I will not let those other assets go. I have no say in the matter. My balance sheet, my lord, is purely a technical divide. Electricity distribution, non-electricity distribution. But that does not mean that WBRC will allow me to retain that dividing wall. It may shift the location of the dividing wall. And maybe it may include all my assets as regulated assets. Then, my lord, they hammered one point home, my lord, which really hurt us because it's false. They said that we have acted clever. We gave the guarantee because we stood to get $300 million, 1,994 crores, and we stood to get $40 million. My lord, what they've suppressed is that both those amounts, 300 million and 40 million, were to go to MEL. They were not to come to me. And the moment they went to MEL, lenders picked it up. Your lordship would recall, your lordship asked a question. What was the tearing hurry to get this guarantee? Why didn't you let IPCL go and get prior permission? The tearing hurry, my lord, was the 30th September 2016. My account would become an NPA. And they knew that NG is willing to infuse 1900 crores. So they were salivating that we approve this. 1900 crores comes into Meenakshi. It'll wipe out the NPA overdue status and our account will be a healthy account. That is why they were desperate, my lord, to get me into this guarantee as soon as possible. On the second payment of 40 million, yes, my lord, that also I was supposed to receive and I was supposed to put it into MEL.
None of this is in the pleading.
One moment, sir. It's in the documents. It's in the documents. And my documents form part of my pleadings. I have attached all the sanction letters, my lord. The sanction letter says that NG will infuse 300 million into MEL. I'm not saying that. Lender said that. And NG did perform. It did infuse 300 million into MEL, which the lenders appropriated towards the overdue and saved the NPA. Otherwise, my lord, if I was declared NPA in 30th, my lord, simple logic. If Meenakshi was declared NPA on 30th September 16, the whole story was over within 4 months thereafter. The banks would have to initiate punitive action in the courts. And the IBC was in force at that time. So it is the lenders to save their account from becoming an NPA. They waived everything and anything under the sun, my lord, just to get that money into MEL. Even that 40 million, my lord, I was supposed to get it and I was supposed to immediately put it into MEL. I received it. I do not deny it. And all I told the lenders was, let my taxation on this 40 million be over because the income tax department has raised a demand. The moment my balance liability is crystallized, I'll put in the money. But pending that 40 million, I put in 189 crores separately, which they don't talk about. And that 40 million, my lord, is almost equal to the 189 crores that I put in separately. So what benefit have I got? I have not tricked anybody. I have not misled anybody. I was the one who shouted from the rooftop that I cannot give this guarantee without WBRC permission. They said, don't worry. We will get legal opinion that you can.
This is not in the pleading.
My lord, it is all in the pleadings, my lord.
It is not, my lord, a part of the plaint.
It is very much a part of the plaint. Then, my lord, next page, point number 5. Your lordship asked this crucial question that why was IPCL not granted time to go to WBRC and what is the tearing hurry? This was the tearing hurry, my lords, to get in $300 million into MEL. Point number 6. Was the onus on IPCL, my lords, to declare by affidavit that it could give the guarantee? I gave the example, my lord, that when a man is marrying a woman, perhaps forcibly, only that man who's marrying the woman forcibly will require the woman to give an affidavit that she's marrying him voluntarily. If your lordship will see my sanction letters issued by the lenders, there's not a whisper of an affidavit. But suddenly someone woke up in the morning of 23rd September, scratched his head, said, you know, this is a little funny situation. Let's take an affidavit also from them. Where will they go? They'll agree. So they said, they put a paper on the table. We want this affidavit. Goswami said, okay, sure. But Goswami certifying that IPCL can give a guarantee. He's not Parliament, my lords. Parliament has said, under the Electricity Act, through subordinate legislation by WBRC, that I have to take prior permission whether I like it or not. So my giving an affidavit to lenders who have obtained legal opinion that I cannot give this guarantee is, my lord, double speak. And I'm using the most polite word I can find, my lord, when I say double speak.
Yes.
Then, my lord, they also hammered that though I've gone to WBRC, there's not a whisper in the show cause notice that the WBRC has said the guarantee is void ab initio. But Lord, WB is not a declaratory forum. WBRC is not here to declare yes or no whether my guarantee is void or not void. That the law will decide. WBRC is the punishing forum. It made a regulation. I acted in breach. It's now going to take action. Then, Lord, they raise the point that if a contract is entered into in breach of a statute, can it be said it is void? That was the argument of Mr. Jishnu Saha day before. Manalal Khaitan, my lord, at the risk of reiterating, this is a very important judgment, my lord. Please allow me to read it out, lords. Page 6, para 19 of Manalal Khaitan, where a contract, express or implied, is expressly or by implication forbidden by statute, no court will lend its assistance to give it effect. And there is a citation, my lord, an English citation. A contract is void if prohibited by a statute under a penalty, even without express declaration that the contract is void, because such a penalty implies the prohibition. The penalty may be imposed with intent merely to deter persons from entering into the contract, or for the purposes of revenue, or that the contract shall not be entered into so as to be valid at law. A distinction is sometimes made between contracts entered into with the object of committing an illegal act and contracts expressly or impliedly prohibited by statute. The distinction that in the former class, one has only to look and see what acts the statute prohibits. It does not matter whether or not it prohibits a contract. If a contract is made to do a prohibited act, that contract will be unenforceable. In the latter class, one has to consider what act the statute prohibits, but what contract it prohibits. One is not concerned at all with the intent of the parties. If the parties enter into a prohibited contract, that contract is unenforceable. And my lord, there are some citations. Then para 20. It is well established that a contract which involves in its fulfillment the doing of an act prohibited by statute is void. The legal maxim a pactis privatorium publico juri non derogatur means that private agreements cannot alter the general law. Where a contract, express or implied, is expressly or by implication forbidden by statute, no court can lend its assistance to give it effect. What is done in contravention of the provisions of an act of the legislature cannot be made the subject of an action. If anything is against law, though it is not prohibited in the statute, but only a penalty is annexed, the agreement is void. My lord, please mark this sentence. This sums it up. What they are saying is that the 5.13.2 does not say that a guarantee given without prior permission is void. Here it is up. It need not say that it is void. The very fact that a penalty is stipulated means it is void. In every case where a statute inflicts a penalty for doing an act, though the act be not prohibited, yet the thing is unlawful because it is not intended that a statute would inflict a penalty for a lawful act. I mean, it's beautiful terminology, my lord. It just sums it up very, very clearly. Penalties are imposed by statute for two different purposes: for the protection of the public against fraud or for some other object of public policy, and two, for the purpose of securing certain sources of revenue either to the state or to certain public bodies. If it is clear that a penalty is imposed by statute for the purpose of preventing something from being done on some ground of public policy, the thing prohibited, if done, will be treated as void, even though the penalty is imposed is not enforceable. And then, my lord, they talk about section 108 of the Companies Act. And my lord, our show cause notice under section 142 of the Electricity Act, I've not quoted it here, but if your lordship may kindly just please make a note. It says, in case any complaint is filed before the appropriate commission by any person, or if that commission is satisfied that any person has contravened any of the provisions of this act or the rules or regulations made thereunder, or any direction issued by the commission, the appropriate commission may, after giving such person an opportunity of being heard in the matter, by order in writing, direct that without prejudice to any other penalty, which he may be liable under this act, such person shall pay by way of penalty, which shall not exceed 1 lakh rupees for each contravention, and in course of a continuing failure, with an additional penalty, which may extend to 6,000 rupees for every day during which the failure continues after contravention of the first such direction. Now, my lord, this contravention is not curable by me. I cannot take back the guarantee. So if your lordship will read it in conjunction with 5.13.2, read with section 142, the matter is very clear that there is a penalty. They knew it. But Lord, this is the best part. I never hid that I am bound by WBERC regulations. It was the elephant in the room. They knew it. They devised a solution, which I will show. I'll show letters where they said that our LLC will certify that you can give this guarantee. Go ahead, certify. Please see, my lord, page 15, my lords. It's a 2-page letter from my side to them. And my lord, the relevant portion on page 16, where I asked their condition number 21, it read as put out on the left side. I requested that it be read as put out on the right side. their condition said, corporate guarantee of IPCL to be provided, LLC to certify whether IPCL is required to take permission from State Regulatory Commission under clauses of licenses, if any, as IPCL acts as distribution franchisee, necessary due diligence to be done by law division of REC. I request him, my lord, that it be rephrased as corporate guarantee of IPCL to be provided on all assets other than WBRC regulated assets. Additionally, with respect to WBRC regulated asset, following condition be stipulated. IPCL to provide an undertaking that any surplus funds that are generated from WBRC regulated assets, etc., 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 and then the above undertaking shall form part of the corporate guarantee of IPCL. Now, my lord, they did not relax the LLC condition, but they accepted my request, and they put these clauses also into the contract of guarantee, that there is a ceiling on my exposure, which is my non-regulated assets. But my lord, but the question still remains, I have given a guarantee. The WBRC regulation do not say that out of regulated assets, take my prior permission, out of non-regulated assets, you may do what you want, because then that will lead to chaos. Everyone will say, I have given a guarantee out of my non-regulated assets. Then where is the role of the regulator? So the regulators to decide, my lord, what are my regulated assets? What are my non-regulated assets? That is why even otherwise, my lord, even if this guarantee is not void, it's a contingent guarantee. It cannot be enforced till WBRC says what are my regulated assets and what are my unregulated assets. But I'm not diluting my attack. I'm not saying it's a contingent guarantee and the matter ends there. I'm saying it is a void guarantee, but purely in arguendo, assuming without admitting that it's not a void guarantee, it's a contingent guarantee for which they have not ever approached WBRC till date to identify what are my regulated and what are my unregulated assets. Then, my lord, they harped a lot. I mean, I'm now on point 8, my lord, page 7. They harped a lot on my semantics in para 97. My lord, para 97 firstly was bar of other laws. It was not interim relief. And to show that there is no bar of other laws, my lord, there was 2.5 pages of text, 2.5. They only look at the first quarter. I don't want to dilate, my lord, because I've taken your lordship through the para 97 in the past, but it is crystal clear. I mean, they are admitting that what I have sought is DRT. So I gave the virus example. That is the virus in the air. Why would I go to a hospital if the virus can give 5 diseases, A, B, C, D, E? What sort of an idiot am I to go to a hospital and say, inoculate me against disease B and disease D? I'll say, inoculate me against the virus. So if I'm asking for inoculation against DRT, does it stand to reason that the reasons for protection from DRT being identical to reasons for protection in IBC, I will not ask for IBC? I mean, my reasons are identical. I can understand if my reasons for protection against DRT were X and my reasons for protection against IBC were Y. And I said, in view of X, please protect me against DRT. I have not said that. My reasons are common, whether DRT, IBC, civil suit, or whatever you want to do. You have no right under the contract of guarantee. Then, my lords, on point 9, they said there's a bar of jurisdiction. They've already argued this, my lord. Their Order 7, Rule 11 has been dismissed, 8 July. They are right that they've challenged it. My lord, but that's a challenge in name. It's not a challenge in substance. They filed that writ petition sometime, I think, in August 22. Twice it got listed, all 3 times they took adjournments. And has never been pressed for listing thereafter. So just to keep it as a bogey, to be able to then to be telling other courts that my challenge is pending, my lord, is not a fair statement to make.
Yes, yes.
In any case, my lord, even assuming without admitting that they succeed and my suit gets dismissed, it's an impossibility because NCLT, and I'm using the phrase in section 430 of the Companies Act, Red Book 63 and 231 IBC. This issue is not an issue that NCLT is empowered to determine. Not as the stage of section 7. Yes, if section 7 is allowed, which is summary proceedings, subsequently in section 60, subsection 5, NCLT can go into all proceedings, all issues. But it cannot, all issues cannot mean going back to the issue of section 7. Section 7, my lord, is purely summary proceeding. And I've given case law of Madras High Court, Stanbic Bank, Ghana Limited. I've given NCLAT judgments on the subject that NCLT proceedings at the stage of Section 7 are purely summary. They're relying on innovative and embassy property developers. It's there in the written note. That is true, but that's at the stage of Section 60. It's not the stage of Section 7. Then, my lord, on point 10, they were hammering debt recovery proceedings and proceedings for recovery of debt. I had submitted to your lordship a comparative chart, my lord. I will not detain your lordships on that. In my earlier written submission, I've given that comparative chart, my lord. These proceedings are as much for recovery of debt as, for example, proceedings are. But they are called resolution because that is a sophisticated label given to a third party coming in. In other words, the debt is being recovered not from sale of assets, but from infusion of capital by a new party. But that capital, my lord, is for recovery of debt. It is not to build a memorial or build a community park. It's to resolve the NPA status that triggered the IBC. So in no case would ever a resolution plan be. I'll give an example, my lord. Suppose my NPA is 1,000 crores, but my total liability is 5,000 crores. Never would a resolution plan be accepted for less than 1,000 crores. Because my NPA status does not go. Unless, of course, my lord, there is no assets in the company and liquidation value and all the other factors will kick in. Then, my lord, they've hammered at point 11 that we've said nothing about pleadings. I think, my lord, my learned colleague is so fixated on para 97 that he's not read any other part of the plate. But these are the multiple locations, my lord, where we pleaded fraud, coercion, misrepresentation, and inducement. And I stopped at etc., my lord, because I thought 8 is enough. But it'll go on to about 15, 20. It'll also be there in my application for interim relief. Then, my lord, they said the point that IPCL has given a warranty as if I am descended from the heavens. And if I give a warranty, that warranty is true. No, I have given a warranty. But what warranty have I given? What you have asked me to give you. And what warranty have you asked me to give you? What your LLCs advised you. And why has your LLC advised you? Because on your instruction, he's obtained legal opinion from 3 jurists. So if my warranty is wrong, does not mean the fact warranted is true. It means I am liable for a false warranty or a wrong warranty or an incorrect warranty. Sue me. But you cannot say that if a warranty is given, that means that the thing warranted is true and correct. That would be an absurdity, my lords. All that means is the warranty is incorrect and therefore remedy then has to be sought by the recipient of the warranty for breach of the warranty by the giver or for giving an incorrect false warranty. They could make out, for example, my lord, if they're creative, they could make out a criminal case. If under section 419 of the 415 of the IPC, if they can make out a case that I induced them to do something which they otherwise would not have done, irrespective of money changing hands will come into 420. But suppose, my lord, my learned friend gives me a lunch appointment at Park Street for 1 o'clock, having no intent to be there. And he knows that my coming and going will waste 2 hours of my time. That's an injury to me. If he gives me an appointment at Park Street at 1 o'clock, I go there, he's not there, I can prosecute him for cheating under 415, though no money has changed hands. So if I've given a false warranty, take action in accordance with law. But you cannot say that because your false warranty is false, I will say you are prohibited from giving a false warranty, ergo your warranty is true. I mean, that's an absurd argument. Then, my lord, they said that we are stopped by litigation history, the estoppel of litigation history. My lord, they are stopped. Because in the Hyderabad suit, they never filed a written statement. Therefore, all that we have asserted in this suit, which includes part of the Hyderabad suit, stands admitted at Hyderabad. And it's my respectful submission, my lord, that if you make a stand before court A, you are bound to that stand before court B, C, D, E, F. You cannot change. It's not as simple as approbate, reprobate, my lord. Approbate, reprobate on law, no difficulty. Keep changing your stand based upon improved legal advice, but not on facts. Facts will not be approbate, reprobate. It will be perjury. For example, my lord, in the new court, if you change your stand, you have a verification in the affidavit, though it's not there in West Bengal, my lord, but usually that verification is there, that I swear that nothing material has been suppressed therefrom. That verification then, my lord, becomes a prosecutable false statement. That you're suppressing, that here somewhere you have said A, here you're saying B, but you're not disclosing here that you said A. That will make it perjury. Moreover, my lord, please see page 9, item B. They are also stopped, my lord, because my main antagonist is SBI. He never filed a reply to the interim relief application. I had shown your lordship, my lords, on the last time. Their entire phraseology that I'm filing this reply on behalf of other people. Okay. You file it on behalf of other people. What about your behalf? There's no reply by SBI. So they are stopped, my lord. But may I say one thing, my lord? A lot of these points that I'm addressing at the instance of my learned friend are matters for the trial court. We are here, my lords, only for interim relief, yes or no. And that is based on 3 legs only. Irreparable injury, balance of convenience, and prima facie case. But since he raised the point, my lord, I am addressing it. Then, my lord, they said wrongly, item 14, they said that we woke up, IPCL woke up only when the demand was raised. My lord, may kindly note these dates. My lord, it's there in the plain. The first demand was raised in December 17. The second demand was raised in May 18. And May 18 is when the shares were transferred. My first approach, admittedly by them, is November 17. Is WBRC reply? That means I must have gone 2-3 months before, probably in June, July, August 17. So it's wrong to say that I went only when the demand was raised. But even if I did, my lords, even if I did, you get my suit dismissed. I'm not on the suit. I'm on the injunction. Allow me to live till I prove or you disprove my case. At least I have that much right in law. Then, my lord, they say that the balance sheet itself shows that prior permission is not required. I've already addressed this point in another point, my lord. I am nobody to divide my assets. It's for WBRC to say. Point number 16. They said, my lord, that they were not injured by the phraseology of the first stay order of 24 January. They were agreed by 11th February, which was set aside by High Court. My lord, that's wrong. 24 January, even after 11th February was set aside by 8th August order of your lordship, or 3rd August order of your lordship, they respected the stay before NCLT at the risk of contempt. In other words, my lord, this is very important, my lord. In other words, the phraseology in the first order, though it said debt recovery proceeding, they knew it applied to IBC as well. And if your lordship desires, I will file the whole order book of NCLT, which show that they kept seeking adjournment because of this stay. It's only after 9th September, when the impugn order was passed, that they said, now there's no stay, proceed with IBC. Then, my lord, they also hammered a point that on 24th April, we gave an assurance to NCLT that we will cooperate. Of course, my lord, I will cooperate. But my cooperation will not be that I am cooperating that for you, you are digging my grave and I'll help you digging my grave. Cooperate means, yes, I will take no adjournment. I will present no obstruction to adjudication of the petition. And I stand by that. Adjudication of the petition, according to me, means dismissal. It does not mean it's going to be allowed. But that is what I said to NCLT, and I abide by that. Then, my lord, they argued about the PTC case. My lord,
you have already said that for the purpose of interim release, you are not saying.
I am not pressing that, my lord. But I am reserving my rights, my lord, because in the 8th July order of the trial court, it has been clearly said 2 things. Number 1, he is prima facie satisfied that the facts of PTC are different from mine.
Yes,
and number 2, it's too inchoate. We will examine it at the point of trial.
Correct.
This is the gist of the matter, my lords. I only humbly request, my lord, I have a right to remain alive till my suit is decided. If my suit had no flavor of merit, it would have been dismissed with the Order 7, Rule 11. Court has conceded.
Not on merit, actually, Order 7, Rule 11. It is within a very limited, the compass, it has to be done. Merit cannot be a ground so far as
By
Order
merit,
7
I meant, my lord, all their objection that is barred by lords, barred
That
by
is what
this,
is there.
barred by
Barred
that.
by law or something. That you are correct, because those are the instances of the Order 7, Rule 11. No
So, my lord, I am relying on Paradeep versus the managing director of IDCO that if the man himself will die during the suit, unless you protect him, that injunction must be granted.
Yes.
That's the essence of our case.
Yes, thank you.
My lord, my learned friend relies on Manna Lal Khaitan. My lord, he hands up the citation, my lord, in court. My lord, unfortunately, my lord, the question, my lord, as to what, my lord, is an illegal, my lord, contract, which is, my lord, under, my lord, the parameters of section 23 of the Contract Act, my lord, has gone far beyond. My lord, today, my lord, every contract, my lord, which says, my lord, that you cannot do it without my permission, will it become void?
No.
No,
I have not
so
said
far
that.
as, no, with the greatest respect, my learned friend says, any contract, which, any statute which says that you cannot do something, and if you do something, it'll invite a penalty.
No, that's not my.
Which
that's
means,
not my
the contract will survive, you will be liable for a penalty.
No, no, no.
With the greatest respect, Mannalal Khaitan, is on a specific purpose. Mannalal Khaitan was on the question of whether you can enter into an agreement for transfer of shares and say you've transferred the shares without executing the transfer deed and handing over the share certificate. That was on section 81 of the Companies Act. To the best of my recollection.
108.
108, my learned friend says, this 1956 Act, we are.
That is 108.
Yes. But Mannalal Khaitan was on the question of what are the requisites of transfer. Today, you can't say shares have been transferred to me without a share certificate, deed. Or you can't say shares have been transferred to me without executing the share transfer document. These were the questions. But here, the question is totally different.
So that we got it. Yes. Let us decide on that.
My lord, I can give 150 other judgments that if a thing is prohibited by statute and you enter into a contract.
What is
that contract is
prohibition
void.
by statute?
I think no judgment is required because the statute is very clear on this. What
we
is
had relied on-
prohibited for all intent purposes.
No, kindly allow that in my
Ex
note. Your
Dolo
lordship will
Balo
find-
will get it.
Your lordship will find, in my notes, there is reference to BOI Finance Limited versus Custodian and others. That in paragraph 33, was dealing with the prohibition of the Reserve Bank of India. And may I just
read it.
May I just read out this
My
one
leisure
paragraph?
time, I have read it to some extent.
Kindly just one paragraph, kindly.
Yes.
The aforesaid principles will clearly be applicable in the present case as well. It's there in my note. The non-compliance of the directions issued by the Reserve Bank may result in the prosecution
Is there.
and or levy of penalty under section 46, but it cannot result in invalidation of any contract by the bank with a third party. If the contention of the custodian is accepted, it will result in invalidation of the agreements by the banks, even where third parties may not be aware of the directions which are being violated. To give an example, if the Reserve Bank cannot give any loan, but without informing third party, the bank, while exceeding its limit, gives a loan, which is then utilized by the bank's customer. It will be inequitable and improper to hold that as the directors of the Reserve Bank had not been complied with, directions of the Reserve Bank had not been complied with by the bank, the grant of loan cannot be regarded as valid, and as a consequence thereof, the customer must return the amount received, even though he may have utilized the same in his business. Well, I shall not read any further. The principle is very clear. It may result in a penalty. It may result in a prosecution. It may result in a censure. But it cannot invalidate the document which is entered into with the third party. And the guarantee itself, your lordship has seen, repeatedly says, I undertake, I warrant, I represent, so on and so forth. But Mannalal Khaitan has to be understood in the context in which it was delivered, on the facts of the case.
BOI versus
You cannot
custodian.
extract one paragraph out of a judgment
No,
and say, that is the
What do you
proposition.
think that we will not read the judgment?
My lord, my
My learned friend has not addressed your lordship on one more thing. That is, on whether the NCLT has the power to decide. Now, normally what we see in the NCLT is whenever a person is sued on a guarantee that has been executed, a corporate guarantee, say, that person can come and say before the NCLT the guarantee is invalid.
cannot. I'm sorry.
He can say that the guarantee is void in law. He can argue that the guarantee is void in law. That is something that the NCLT is clearly empowered to adjudicate.
I'm sorry.
Now, my learned friend says, I'm sorry, but the question is then what does the NCLT do? Anyone comes and says that today a guarantee is given, yes, but it's not void. The NCLT says very well, I dismiss the proceedings.
I'll answer that, my lord.
The question is, very clear. NCLT, has a power to decide on, applications presented to it under section 7. Application is, on the basis of a contract of loan, a contract of guarantee, any other similar contract. Now, when a contract of guarantee is given, it is open to my learned friend to go and say that this guarantee is a guarantee which is void in law. Why cannot that argument be pursued there?
My lord, with due respect, my lord, my learned friend is now, it's not fair. I
That
given
is
the judgment, my lord.
Consider it. That's why I was just thinking, because yes, since you have cited one new judgment, so that's why I permitted him to make it. Otherwise, reply to a reply.
No new judgment, my lord. Mannalal, I have given my earlier written submissions.
Anyhow, it's not required. Anyhow. Yes, let us see. Yes, hearing concluded.
Your lordship is
Give it to
inclined to
us.
pronounce
Give it
the
to
order
us.
in court, my lords.
Give it to us. 1-5. And the irony of the thing is that whole of the week, I will not be available after 2. There is an interview which is going on for a promotion of a fast track court to a ADJ.
My lords, I humbly
a
request,
part
my
of
lord, in my appeal and in my can, your lordship will see.
Probably, I will just try to do it within this weekend so that it can be made ready for Tuesday.
Could we know the mind of the
Subject to
court,
my
my lord? The
brother
reasons
concurring
can
with
No,
follow.
of course. But my lord, we kindly consider, my lord, the statutory bar imposed by the IBC, my lord, which we have taken in note.
Let us see, send it.
My lord, in my appeal and
এটাতে দুটো করে দিও, একটা তোমার IBC একটা ওর সঙ্গে রেখে দিও। ওর সঙ্গে একটা IBC করে দিও, আর আমাকে পাঠিয়ে দিও।
Note করেছে।
my lords, in my appeal and in my can, your lordship will see a plethora of extracts of judgments that Section 7 proceedings are summary in nature, no declaratory relief, no no contest of adjudicated facts.
Don't inculcate any apprehension that at least I will not go through all this. I will go.
A summary
word by word,
adjudication is
word
also
by
an
word.
adjudication.
Don't worry. Yes.
And my lord, if today, my lord,
Yes, call the next matter.
Number 6.
In fact, my lord, just today an enclared judgment
For-
has come. No discovery allowed in Section 7. I will hand that over, my lord, along with, to my learned friend. So no discovery. Why? Summary proceedings.
My lord, it is
No
my lord, a
adjudication.
matter of invalidity. Where's the question of discovery?
No,
We can argue
invalidity.
it before the enclave.
Let us
Invalidity depends on
call
facts.
the another matter.
Sorry, my lord.
Much obliged, my lords.
Yes.
Number 6 to 8.
I think respondent, Mr. Ghosh was making his submissions.
May I start?
Can you do it on another day? Because at least this bench has really focused on the earlier.
Tuesday, my lord.
It's better so that let us.
Lord, may I file, give the note, so if lordship can, my lord, read that and come. They
Give-
have not given, I'm giving.
Give,
We have also prepared a notes, but we have not started our arguments. If your lordship.
No, I had framed my
you
argument.
just give it so that we can on
Copy the
Tuesday.
lordship के दिए दाओ ना.
On Monday, I assure you that I will go through that, not in the weekend. Weekend is reserved for this.
Note is 9 pages. I have given all the judgments I want to realize.
Same here, lordship, note is 3
Please
pages.
indicate the
but,
relevant paragraphs and then give it.
In the body, it's indicated. In the body, my lord, it's indicated. In the body of the notes, the relevant paragraphs.
Same here, lordship, note is 5 pages, but the judgments have been annexed.
Yeah.
But we
I
have
also
not,
given a list of
but
dates of-
again, I'm saying, lordship, we have not started our arguments. We'll start after Mr. Ghosh finishes.
It's true. Let the written notes of argument filed today be kept on by the respective councils be kept on record. However, on the request of the respective councils that they may be permitted to make an oral arguments, let this matter be fixed on next Tuesday.
Great.
Yes. Taku. So, hearing of any other matter,
No, my lord, only one thing, my lord, I was waiting for my matter, and my lord will perhaps not sit, my lord, on that side of my lord today, my lord, after recess. My lord, the item number 1 of my lord's court for number 4 list is for extension of my interim order. If my lord, if the document goes to NCLT again, my lord, it has to be, my lord, difficult like yesterday's matter. My lord, state the order, only my lord, need to extend. I've just got the copy of the my lord's order.
so that has been done.
No, not been extended. My lord, it has, my lord, it has.
Who is for the other side?
My lord, I've given notice to OL, but they are not opposing really, my lord knows.
No, whatever.
And only my lord extends the my lord, I'll again give notice. I've given notice to them. But only difficulty is that if that thing happened, then my lord, it's difficult, my lord, like yesterday's
The
matter.
interim order is up to.
My lord, it's up to my lord, 10th of April. My lord, my lord, we could not assist your lordship because my lord is taking up the commercial matter. But my lord, only thing is my lord extends that, my lord.
show us the notice of the
Yes, yes.
notice to L.
Like these are the two orders and the notice. My lord. I have only one copy of the notice. My lord.
Let us go there and sit. 2-minute adjournment. We are going to courtroom number 4. We'll sit for this matter.
Very good. Obliged.
Ekhoni.
Obliged.
Items 11 and 12 maybe had to Tuesday.
Next Tuesday.
হ্যাঁ। এই একটা ম্যাটারের জন্য
এখন যাবে হবে ওদের
চারে গেল দাদা দাদা সবাই তো স্কুলে যাচ্ছে
করা যাবে
ও তাই নাকি? না, এটা এই সপ্তাহে বসছে না, জুডিশিয়াল অফিসারদের ইন্টারভিউ করতে। ও এইখানে গোটা সপ্তাহটাই দীপক পরে আর বসছে না, জুডিশিয়াল অফিসারদের ইন্টারভিউ করতে।
ও তাহলে এইগুলো যেগুলো থাকবে সেগুলো কবে থাকবে আবার? মঙ্গলবার।